We are closing out the afternoon in conversation with Judge John Jones III. And I just wanted to mention very quickly that the judge has received numerous accolades during his career. And in 2006, Time magazine named him one of Time's 100 most influential people in the world. I am not even the most influential person in my house. So I am indeed impressed. So please, everyone, sit back and enjoy this conversation between the judge and CFI President and CEO, Robin Blubner.
Hello, good afternoon, everyone. I just cannot tell you what an immense honor it is for me to bestow the Defender of the Constitution Award on Judge John E. Jones III. So let me tell you why. First, Judge Jones has had a stunning career of public service at the highest levels. He is the current president of Dickinson College in Pennsylvania, a post he has held since 2021. Before that, Judge Jones was the chief judge of the Federal Middle District Court of Pennsylvania. As we heard, he was recommended to the bench by Pennsylvania Senator Rick Santorum and nominated by President George W. Bush. And then Judge Jones was confirmed by the Senate in July 2002 unanimously. Unanimously. It's really hard to believe that there was a time when someone highly qualified and meritorious could transcend partisan politics. But Judge Jones is a living example of a saner time. Now, we all know that Judge Jones was the trial judge in the Kitzmiller case. We'll be going into depth on that case together. He saved science's butt. But let me introduce you to a couple of other cases that you might not be quite as aware of. So in 2003, Judge Jones stood up for freedom of speech by striking down a speech code at Shippensburg University. So the code required students to mirror the university's ideals as they apply to cultural diversity and social justice and racial issues. Blatant censorship, as Judge Jones accurately stated. He said, good intentions do not justify censorship. Another lesson we seem to have lost today. And then there was the case of Whitewood versus Wolf from 2014, in which Judge Jones struck down Pennsylvania's ban on same-sex marriage. The judge ruled that Pennsylvania's statutory ban on recognizing same-sex marriage violated the due process and the equal protection rights of same-sex couples. He said all couples deserve equal dignity in civil marriage. He also summed up the ruling by saying, we are better people than this. He said these laws against same-sex marriage should be discarded into the ash heap of history. The next day, the Pennsylvania governor said, we are not appealing, and same-sex marriage is legal in the state. And finally, the other day, I saw Judge Jones on CNN. He was on Anderson Cooper's program. And what was he doing? He was explaining how President Trump is overstepping the provisions of the Alien Enemies Act by using it when the nation was not at war in order to round up undocumented immigrants. So he's not a sitting judge anymore, but he's actively defending the Constitution for all of us, regardless of party or affiliation. I can think of no one more deserving than the defender of the Constitution Award, Judge Jones. We're going to be having a conversation for about a half hour, and then we're going to actually open it up for questions. So start to think about some of the things you might want to ask the judge within the next half hour. So, Judge Jones, first of all, would you mind giving us all a little biographical sketch? Tell us how you came to be a lawyer in the first place.
Well, first of all, you can call me John. I'm a recovering judge, so we don't have to stand on ceremony. And after that, the eulogy you just gave me, I knew we could probably end it right there. So, Robin, I grew up in anthracite coal country in Pennsylvania, and my ancestors came from Wales and Ireland and Scotland and northern Europe, and many of them worked the mines in that area. I had a grandfather on my father's side who had an 8th grade education, but made himself successful in business and was able to educate my dad and my uncle in college and believed in education. I didn't have lawyers in the family, but it always seemed alluring to me to follow the law. And I also was interested in people who were in public life. And it seemed to me in my younger years that many of the folks that I admired and studied who'd gone into public life happened to be lawyers. And then as that sort of moved along, I thought being a trial lawyer would be a good profession to go into. So I pursued the law, and as was noted, I engaged in politics back when you could be a moderate in politics, and I freely participated in the process. I had the great good fortune to be a senior member of former Pennsylvania Governor Tom Ridge's administration, a tremendous individual and probably the foremost mentor that I've had in my life. And I grew up in a small town, as I said, in northeastern Pennsylvania, a couple thousand people, and I thought when I was young, if I played my cards right, maybe I could be a county judge someday. When I was a young lawyer, I thought that, and I had the great good fortune to get on the federal bench in my mid-40s, and thought that might be the last sort of big stop in a career, and I was so honored to be able to serve for 19 and a half years, and very unexpectedly, my alma mater came calling. I happened to be the chair of the Board of Trustees, and they asked me to step off the bench and to lead my alma mater, Dickinson College, which, for those who don't know, is a liberal arts college with a couple thousand students in central Pennsylvania. It's a very storied college. It's been around since 1783. It was the first college chartered in the country after the new nation was created. Just talking to Ed Larson about John Dickinson, after whom the college was named. And so I've been doing that for 4 years now, starting my 5th year as president. Is a wonderful job, and it's given me the opportunity to, as you said, comment on the affairs of the day. When you're a judge, you're constrained by the code of conduct for federal judges, which really does not allow you to make extrajudicial statements to comment on things that could actually end up on your docket, and it's very appropriate that you have that constraint. But it's been very liberating the last 4 years, and I feel very passionate about judicial independence and the role of the judiciary. I am distressed about, and we can talk about this, it's not directly germane to the case, but I'm distressed about the way this administration is treating the federal judiciary, and I'm going to talk about it.
Well, we hope you do. Absolutely. So let's talk a little about the Kitzmiller case. Were you aware before the case was filed of the tumult that was going on in Dover, Pennsylvania?
I wasn't. It was a very local kind of a controversy. The Middle District of Pennsylvania goes from the Maryland border to the New York border and is the sort of wide swath of the middle of Pennsylvania. The district contains about 4 million people. So, you don't see every local paper. The York papers, which cover the area where Dover is, had a lot of articles, as I saw later, about the controversy, but I really wasn't cognizant of it at all. And I have to tell you that if I had heard about intelligent design before I received the case, I don't remember it sticking in my head. The first time I heard about the case, and I've told this story very frequently, I was driving home from my chambers. It's a true story. And back before everybody started listening to satellite radio, I was listening to a local radio station as I would sometimes on the way home. And they announced that a group of parents in Dover had filed a federal lawsuit, and there had been a big press conference with the ACLU and the other associated attorneys like Richard, and that was in the Capitol Rotunda, which was a big deal, announcing the suit. And I remember idly thinking, knowing it was filed in my judicial district, I thought, and there were about 10, 11 judges in the district, and I thought to myself, geez, it's an interesting case. I wonder who's going to get that. Found out the next day.
As you were starting the trial, did you appreciate just what an impact this trial would have on the law and on, ultimately on science textbooks?
Well, kind of. When I first received the case, I really thought, given the dynamic of the case in the first month or so, that it seemed like a case that at some point would settle. And then I had a couple conferences with the lawyers, and you could just tell by the body language and the demeanor of the lawyers, particularly on the school board side, that they were determined to take the case to trial. So we moved sort of inexorably towards a trial. This all went on in the beginning of 2005, and we scheduled trial for September, and I blocked out my calendar to do it. And you had a sense that it was gaining more and more national and international attention. But I remember the first day of the trial so vividly that, this is sometimes you could be a judge and sit for decades and decades and it never happens to you. Well, as I came to the courthouse that day, the whole federal courthouse was ringed with satellite trucks, and from the major networks and so forth. And I went into my chambers, and my courtroom deputy just kept coming into chambers, and she'd say, I don't know where to seat people. I mean, there's so many people that want to see us. We had overflow courtrooms it was televised, and then she'd say, Jake Tapper's sitting here, so-and-so's sitting here. And I finally said to her, look, you're freaking me out. I mean, I have to preside over this case. And I went out, and it almost took my breath away because I had never seen the courtroom like that. I tried some pretty high-profile cases as a trial lawyer, but I just had no idea. And the sketch artists were there, and because you don't televise federal court proceedings. And I found that once we got started, you did your job and tamped that down. But it was an absolutely unusual experience and something I'd never been through before, just the sheer notoriety of the case. And every day it was being written about, depending on the developments in the case, but some of them were quite dramatic, so it was written about in papers really across the world.
Yes, absolutely. Many of us were following this case as it was unfolding. And just a personal story, I was at that time a syndicated newspaper columnist in Florida. Before that, I had been the director of the ACLU of Florida, so you knew where my sympathies lied. But I'll never forget the day when your ruling came down in December of 2005, and we'll go back and talk a little more about the trial. But I just want the audience to know that I was so nervous about the ruling because I thought, and forgive me for this, but I thought a George W. Bush appointee may not stand up for science in the face of religious incursion. And I thought science education was going to take a big hit. So I sat down with your 139-page ruling and your full-throated defense and brilliant defense of science and the way you methodically answered each argument against evolution, and I choked up. I started crying. I've never before cried reading a judicial ruling. I'm not even a crier. And I was so emotional, so grateful. You stood up for science in such a profound way that you, at that moment, became my hero. And I'm sure many in this room feel exactly the same way.
That's very kind. Well, as you can tell, that's very kind. Thank you, and thank you, Robin. Thank you, everybody. But I can't help myself, a little levity. So the then president of my college in the office I now occupy, a guy by the name of Bill Durden, was sitting with his provost, Neil Weissman, and we had put out essentially a notification. Our administrative office in Washington urged us to do this because of the media interest and said, we're going to file this decision tomorrow so that everybody could be waiting for it. And of course, it's filed electronically. So we gave essentially 24-hour notice that the thing was going to be filed. And they later told me, and I say this because you weren't the only one that was worried. So they sat in the office, and Durden said to Weissman, he said, you keep mentioning that he's a graduate of Dickinson College. Look, John's a reasonably bright guy, and if he follows the evidence, and from what I can read, it looks like he's gonna strike down this policy. And Weissman said, yeah, I think that's fair. Looks like he's going to do it. And they paused as it was getting dark outside, and Durden looked over at Weissman and said, Neil, he said, you don't think he's going to screw this up, do you? Set the college back to the Stone Age. So it all worked out.
Oh, it certainly did. So can you tell us a little bit about the trial? It was a long trial. Extremely detailed scientific evidence was presented. Can you give us some stories?
Yeah, it is really important. First of all, what was sometimes misunderstood and written about in a way that was totally misleading was that they said, well, who is this judge to arrogate to himself the ability to decide this case? Well, and why did he get rid of a jury? Well, you don't have a jury when you're seeking injunctive relief. It's not available. So it was always going to be bench tried, and the lawyers, of course, knew that. And so it's really important for lawyers to understand what they have. Who are they playing to? And what they knew, I think, was that they had a generalist. They had a judge who was not a specialist in any area of science. Particularly, I wasn't. I was a political science major when I was in college, and so they sort of slotted their witnesses in a way that like building blocks. First witness, and you saw Richard Katsky talk about the Miller and Levine text. Well, Ken Miller was the very first witness in the case. Taught introductory, biology 101 to students at Brown University. A devout Catholic, wrote the textbook, the high school textbook on biology, and he put basically a primer on to start the case about evolution. And that was a good thing because, the other question that lay people ask is, well, what did you study up on in preparation for the trial? And the answer is nothing. You can't, because you have to decide the case based on the evidence that is introduced within the courtroom. So outside research is not permitted and is not helpful. Obviously, it sort of pollutes the process. And then we had theologians, we had paleontologists, we had, in a succession. Margaret Talbot is a writer for the New Yorker and wrote a very interesting article called Darwin in the Dock in December before I decided the case. And she said it was like the class that you wish you had been able to take when you were in college, and it really was. Now, sometimes it got pretty deep, there was a book written, several books, as you saw from Richard's presentation, at lunch break, typically I'd have one of my law clerks sneak out to a nearby Starbucks and get a heavily caffeinated Starbucks, and someone commented, they said that in the middle of some really complicated expert testimony, Judge Jones was hanging onto his Starbucks like a lifeline, because it could get mind-numbingly difficult. But so that was wonderful. And then I have to just say it, the sort of mendacity of the school board members. You heard Buckingham, and you heard about Alan Bonzel, who was the president of the school board. It was really unseemly and really distressing. They didn't know. I mean, at the end of the day, those of you who may not have read the opinion, they didn't know what intelligent design was. They just didn't want to teach evolution. We found out later was that their lawyers wanted a test case and were encouraging them to go forward. But at the same time, the sort of think tank, which many of you know about, the Discovery Institute that was pushing intelligent design, was admonishing them that they weren't going to support their effort. They knew that they weren't ready for prime time. So there was some tension, behind the scenes. So there were the expert testimony was terrific, really interesting to see. And then there were moments of pretty high drama in the trial as well during some cross-examination of the school board witnesses and members that was absolutely textbook great. It was some of the finest lawyering I've ever seen.
So, I think I heard somewhere that you said one of the regrets that you had about the trial was that it wasn't broadcast on court TV. Mm-hmm. And why did you say that?
What happened was, remember when I got this case, this is hard to believe, but I had been on the bench somewhere around 2.5 years at that point. So I was a relatively new judge, and I had never really thought about, televising a proceeding, and what Court TV is gone now, but Court TV was in existence. They filed what's called a motion to intervene. They wanted to televise the proceedings, and I called the then chief judge of my district. I said, can we televise this? He said, oh no, you cannot. And there was this, and it's still true. There's a pilot program in the federal courts today that allows some cases to be televised, but there is a policy a pretty entrenched policy that I had to deny the motion because you simply can't. You simply can't, under most circumstances, televise cases. And the reason I said that, Robin, is because there are various press accounts, but I wish, to the point that I just made, I wish that people had been able to see the quality of lawyering on behalf of the plaintiff parents, because it was exemplary, and it was just so good. You can read the transcripts, but if you don't see lawyers in person, you can lose a little bit of the flavor for how good the advocacy actually was. And I'm sorry that wasn't able to be memorialized in video.
Was it also a function of the incredible science lesson that you were learning and the court was being exposed to?
Well, sure. I mean, I think the expert witnesses were spot on. They were some of the leading folks in their fields. I think about them. From time to time, they were playing to an audience of one, but it would have benefited, of course, the public to see more. But I have to say, though, that the press accounts were pretty spot on and captured, the expert testimony well. My regret was more directed to the lawyering, because look, I was a lawyer for 22 years before I went on the bench. People. I get this, they don't love lawyers under a lot of circumstances. I happen to be, proud of my legal background, and I think it would have been good for the profession for people to see it.
There was a part of your decision where you were recounting, I think the witness was Behe, who was an expert in intelligent design, and he was being questioned about his claims about that there are components of organisms that are irreducibly complex, and the plaintiff's attorneys were demonstrating in that moment that, in fact, his concerns had been answered by science. And if you don't mind just recounting the breadth of evidence.
Michael Behe was a Lehigh biology professor, and Michael Behe had written books and is a leading proponent of intelligent design. And interestingly enough, Michael Behe and Ken Miller knew each other before the case, and they had actually done a couple point counterpoints at various colleges and universities, and they would have a beer afterwards. And and flesh it out. And I don't know Michael Behe other than his participation in the trial, but according to Ken, he's a very decent guy, and they would have these intellectual arguments over a beer and kick it back and forth. The difference was that Ken Miller was highly prepped for the case and understood that he was going to undergo cross-examination. It occurred to me with Michael Behe that he kind of thought that this exercise of testifying in a federal court was just an extension of these sort of fun point-counterpoint events that he'd done at college and universities. In other words, there a lot of times what lawyers will do to prep a witness is kind of a murder board. Well, they'll run them through the ringer on cross-examination and get them prepped. I don't think that Michael Behe was prepared for what happened to him, and the plaintiff's lawyer, Eric Rothschild, who was one of the team of plaintiff's lawyers, just eviscerated him and stacked books up in front of him to sort of make a point very theatrically, and he embarrassed Michael Behe because he just didn't have answers to the questions on cross-examination and stumbled over, his own words and his own findings and beliefs about intelligent design. I think it was an absolutely crushing experience for Behe, and I attribute the larger part of it was because he's espousing a theory that really scientifically couldn't hold water, but also because I don't think that, I think he thought that, they were going to play by the Marcus of Queensberry rules, and it was going to be, this was a federal trial, in a high stakes case, and the lawyers brought their A games, and he just wasn't prepared for that.
So the ruling comes out in December 2005, 139 pages. It's a bombshell. It's an incredible ruling. And what was the aftermath? What happened after that?
Well, the first thing, I was sitting in my chambers, and we had gone through the opinion, myself and my clerks, again and again and again. And I couldn't stand doing any more edits. We pared it down. The first draft was longer, and then you pare it down, and you work on it, and you get it into a form that you like. But then I kept kind of compulsively editing it because I knew that it was going to get a fair amount of play. I didn't know how much play, but I finally said one day, we're going to file this tomorrow. I can't do this. I can't look at it anymore. I'm going to just keep editing it, and it's going to drive us all crazy. So we filed it, and I said to my clerks, and this is when I knew that something in my life was about to change. Despite all the notoriety, I still didn't quite grasp the significance. So we filed it, and I said to my clerks, "Hey, turn the TV on." I had a TV in my chambers. And I thought maybe on the chyron underneath, there'd be something about filing a decision. I mean, it seemed like it was going to get some notoriety. And we were watching CNN, and all of a sudden, they had that breaking news song, and my headshot was behind the anchor. And I remember my clerks, they would look at me, and they'd look at the TV, and they'd look back at me, like, what did we just do? And then, of course, the dam broke, and there was all kinds of inquiries from the media after that. But that's when I knew that how it was being received in the world, and I think it was pretty much on the front pages of most every paper when there were still papers the next day.
And I understand you needed 24-hour security for a time.
Well, what happened was that it was a little bit of a bygone time. There was email then, but not a lot of email, and you didn't have social media at that time. Remember, this is December of 2005. But what you did have is the good old U.S. mail, and within a couple days, letters started to pour in, and we started to read the letters and take a look at them. There were dozens and dozens, mailbags full, and it was quite clear. We turned a number of them over to the United States Marshal, and they said these are legitimate threats. They were unsigned, obviously. They were quite clearly from, I'm sorry to say, from the fundamentalist side, and it was, watch out. Watch your back. And so they dropped as happens for judges, when you have a legitimate threat. I had 24/7 security for myself and my family for weeks afterwards. And, I've said, I thought when I got on the bench that I knew that it's not without risk, but I didn't think I was going to get threatened in a case that involved the Establishment Clause of the First Amendment, but that was exactly what happened, and it died down after a time. Well, with the one letter I received, it reminds me, which is a keeper, and I have it someplace in a file. Those of you of a certain age, you may remember a guy by the name of Chuck Colson. Chuck Colson was Richard Nixon's hatchet man. He was the dirty tricks guy, one of the dirty tricks guys in the Nixon White House, and then got put in prison for his role in Watergate, and in fact served time in Pennsylvania in prison in Allenwood. And he had a conversion at some point, and became highly religious, and he wrote an excoriating letter to me about the decision, which was more amusing than not. But given his past, but that was he didn't threaten me, but it was well, I think he said I was probably going to go to hell, but that was, and then and then there were we had the Pat Robertsons and the Bill O'Reillys and the Phyllis Schlaflys and the rest of them, and the Ann Coulters. They all wrote about it and wrote how stupid I was to render the decision, but it was kind of like, who's going to write something today, and it was kind of the usual polemics from the usual suspects.
But it wasn't just your life that was impacted. The school board members had some consequences to them as well.
Well, yeah. So what happened was that it just happened that the majority of the school board, those members were up for, including the architects of the policy, Buckingham and Bonzell, they were up for re-election in November, and that was post the record closing in the case, but before I rendered the decision in December. So those of you who are sort of political science students, as it occurred, it seemed that the trial was a little bit of a referendum, and not in a good way for the school board members. And to the credit of the folks in Dover, this little beautiful community in central Pennsylvania, they voted them out. And so by the time I rendered the decision, the school board had been essentially unseated, and then the case was not appealed. Obviously, by the successors, they wanted no part of appealing the decision after they took office. The new school board members.
I'm about to open it up to the audience for some questions, but I just want to get your forecast, because there are currently serious attempts in states to impose intelligent design requirements in their public science classrooms, including we were among many organizations that helped beat back an effort this year in North Dakota. There was an effort last year in West Virginia. It appears that some states feel that the time might be right to reopen this issue before the U.S. Supreme Court. So what do you think? Well,
let me answer it this way. This is what troubles me in particular, among other things. I mean, the court is moving in directions that I certainly can find some fault with on a number of different fronts. But Richard, my good friend Richard Katsky alluded to this. Trial judges, which is what I was, love to have guideposts that they can utilize, like the Lemon test, like the endorsement test, that they can apply in factual situations to sort of go through a progression to see, in this case, whether a policy violates the Establishment Clause. They don't fit all the time, every situation, and sometimes you have to adapt them a bit, but they're the trial judge's friend. They're gone now. And what that means is that, so now we're supposed to look at the historical record. I don't know what that means. And I don't think any trial judge really knows what that means. So we're going to start ad hocing these cases. That's what's going to happen. And it's happened already. And it's like, I don't have anything to measure whether a particular policy violates the Establishment Clause, but I'll know it when I see it. That doesn't really work. And the consequence of that, or consequences, will be that you're going to get inconsistent decisions in the lower courts. And you've had them already. And the cases are going to percolate up. But, is there any question? There's no question that there's been, it's always been said that the wall of separation between church and state, which some people say doesn't exist, but, I believe that there is a separation, of course, that wall is porous. Well, the attempt now is to just take that wall down. And as Richard said, buckle in, because they're going to continually look for test cases, and I think there's some rocky road ahead.
I'm sure there is. We're all going to be ready for it, though. This is the team. This is team enlightenment right here. Okay. So, people raise your hand. There are roving mics. Okay, over there.
Thank you. I also was anxiously awaiting that opinion as a non-practicing lawyer who went back into science and engineering and who's been an expert witness on complex technical issues. I was really kind of dreading things because I know how hard it is to explain these things and present them to a judge in a way that's really comprehensible and really gets the point across. And hearing you now, I feel embarrassed even thinking that. But I was actually very encouraged when I saw the 136-page opinion because I thought, aha, this is good. If it was short, he would have, I've been really worried that she took maybe a more overview and kind of cut it short, and maybe while defending, well, that's not science. But if you didn't go into detail, the next permutation would have popped up. And when I saw all those pages that took all the ink out of my printer, I went, hey. So was that a conscious decision?
Yeah, no, that's a very good question. There was the challenge I had, because at the end of the day, I think it was a rout in terms of the purpose of the school board. The purpose was clearly religious. You saw, the clip, and the evidence was abundant. And then it became, do I tackle the seminal question of, is intelligent design science? And at that time, as most of you, all of you perhaps know, intelligent design was cropping up at various places around the country. And I thought, look, I've sat through 6 weeks of this testimony, and I felt that I had an obligation to not just, short step it, half step it, but instead write what I saw and have a compendium in the sense, because it clearly, to me, failed its test. Intelligent design did. And I could think of, school boards across the country, or boards of education, having intelligent design presented to them. And I thought, look, you may not agree with my opinion, but at least there's something, that it's written by a federal judge that people can go to and they can look at. And that was the sort of middle part, if you will, of the opinion, and really read what I saw and what I concluded about intelligent design, which to me had failed utterly. The test that it was put to in the case. So that was a very conscious decision. One lighter note about the opinion. So opinions are, when you put them together in a judge's chambers, it's a little like putting together the Frankenstein monster. You do different parts and you have to try to make them fit together. And that was a bear of a case to do, because there were so many different parts to put together. So as we were framing it out, I and my clerks, I had enough, and I had it in my head, and I wrote the conclusion to the opinion, which some of you have probably read. It goes over 4 or 5 pages. And I at the time I wrote it, I was so exercised about how the school board had really hurt the community, because I knew it was going to cost the community money. It was loser pays litigation. It's called 1983 litigation, and it ended up costing the school board between $1 million or the school district between $1 million and $2 million. And I was furious about that. I thought that they had no business. I labeled it breathtaking inanity in the opinion. And so I write this conclusion, and I wrote it hot. And I typed this out, and I think, this is my magnum opus. This is fabulous. And so I take it home. My wife Beth is with me. She's in the back, and I brought it home, and I never did this before, and didn't do it afterwards. And And I said, take a look at this. And she's an old grade school teacher, former grade school teacher. And she put it down and she goes, you can't use this. And she said, this is gratuitous. This is, take it down a notch, she said. And she was right. I didn't need a law clerk. My law clerks didn't tell me that, but she told me that. So what you're seeing in the conclusion is like 2.0 or 3.0. So you have to, but we're all too human, right? And I was angry about what the school board had put the community through, and I wrote it a little bit hot.
Can I see the first draft?
No. No, I don't know where it is. I think it's been deep sixth. It's long gone.
Does someone have, I can't see very well, so go ahead.
Yeah, hello. I'm sure like anybody else, you had your own personal beliefs going into Kitzmiller. Was there any specific arguments that changed your personal views, or was your decision antithetical to your personal opinion, or was it a no-brainer going in?
No, and that's also an excellent question. Look, you're trained as a judge and as a lawyer. You keep an open mind. I had a very open mind about it. It just, I hadn't really thought about evolution, really, in any concentrated way for years and years and years. I was a liberal arts student. I took geology. I didn't have a science focus. I had no reason to doubt evolution, to be sure, but it wasn't like something embedded in me. So I thought, let it run. Let's see what they've got in the case. And so my personal beliefs didn't really enter into whatever they may be. It didn't do. Even if it did do violence to my personal beliefs, that's beside the point. It's you do your job. It's been said about the judiciary and judges that you do justice. Well, that's not really true. You seek justice, but many of the times when you are the presiding judge, that the party that you might want to see win, the more sort of worthy party in your eyes, they don't win because you call them the way you see them according to the facts and law, and that may mean that an entirely worthy party just doesn't have it on a particular day, and they don't have the law or the facts or both on their side, and that's tough, when it happens. So you do your job.
Next here.
Next person with the microphone. I can't really see. Go ahead.
Yes, PBS did a documentary on the Dover, PA trial. Did you see it?
Well, not only did I see it, you're talking about Nova?
Yes.
Yeah. I came to know the Nova folks pretty well. They looked me up. Paula Absel was the brilliant head of Nova at PBS, with whom I developed a very, very warm friendship. And they asked me to talk about the case, within the constraints of my code of conduct, and I did, and came to know them very well. And they, I thought it was exceedingly well done. It was a 2-hour Nova special, and they recreated the courtroom scenes, which was pretty neat, and used some actors because of course, as we said, it wasn't televised. And they interviewed school board members. They interviewed the plaintiffs. It was really well done. I think it's been used as an educational tool. I came to know the Nova folks pretty well. It's a real quality outfit, and very, very well done.
Do you know if it's available on PBS Passport streaming?
I suspect it must be. I know it was on YouTube for a while, but I have to believe you can get it. Yeah.
Judgment Day. It's called
yeah.
Judgment Day.
Judgment
I'll
Day.
look for it. It's on YouTube now. Great. Anyone can watch it.
Possibly one final question?
Yeah.
Hi. Yeah, you describe Michael Behe's testimony as being he was unprepared for cross-examination, but he describes the trial as being Kafka-esque. And I was just wondering, is that just sour grapes, or do you know that of any specific thing that he complained about?
I don't know why he didn't like my decision. I don't know why that makes it Kafkaesque. I think I understand what Kafkaesque is. If being disemboweled, on the witness stand makes it, Kafkaesque, I'm sorry for that. Poor Professor Behe, you may, some of the folks in the audience know this, but I haven't looked recently. I don't know what he's doing, but at the time of the trial, if you went to the web page for the Lehigh Biology Department, they kind of had a disclaimer on there, like, we like Mike, he's a good colleague, but we really don't ascribe to anything that he believes in as it relates to intelligent design. I mean, I'm sure they were cringing because they would write about him as Lehigh Professor Michael Behe. This is not what your marketing communications people want necessarily. Yeah, he took some shots. He wrote a book afterwards, and he had a bad time. So it was.
So as the interlocutor's prerogative, I'm going to ask the last question, and I'm going to preface it by saying, other than the fact that you just had a grandchild, a healthy grandchild, like yesterday or the day before, what gives you hope?
What gives me hope? What gives me hope is that I think at the end of the day, the judiciary will hold up. And I really do. There may be some short-term losses in certain areas, but I've joined 43 other retired federal judges. You may have read about this, and you may read about it. It's called the Article 3 Coalition, and what we're doing is standing up for the rule of law and for the federal judiciary. And I might tell you, I mean, they're conservative and liberal and moderate, and among them Mike Ludig, who you've probably seen on TV, and is a terrific retired judge, and has had a belly full of this, and I'm heartened by that. And look, I'm going to continue to speak out. As you said, I've done my share of talking head stuff, and will continue to do that when I'm called upon. I was there's a nominee to the Third Circuit Court of Appeals in Philadelphia, Emile Beauvais, who's the president's counsel. Well, and I signed a letter with 74 other federal judges opposing his nomination, retired federal judges, and I spoke about it on MSNBC the other day and on PBS. And so we're not going to take this lying down, and so we'll continue to talk about it. I hope on the Supreme Court that some centrists emerge. I'm not joking. I mean, I think things change over time, so it's stay tuned. But I think right now, in our allegedly co-equal branches of government, we have an executive who ascribes to the so-called unitary executive theory, who brooks no interference. We have a completely pliant Congress that lacked the courage, to stand up, and it's fallen on the judiciary. The judiciary was criticized, and of course the Supreme Court stopped universal injunctions. Those universal injunctions were a product of a Congress that has abdicated its responsibility and dumped it onto the judiciary. I'm fine with no universal injunctions. You can style them as class action suits. There's ways to do this. But we need to get our system somewhat more in balance than it is. It may never be quite co-equal. The president may predominate. That's happened over generations. But bless our judiciary and hope that they hold for the future, and that gives me some hope.
Still defending the Constitution. Thank you so much, John Jones.
Thank you.